Welcome to today's session. We are going to learn about the insolvency resolution and bankruptcy for individuals and partnership firms. Application and process. This part shall apply to matters related to fresh start, insolvency and bankruptcy of individuals and partnership firms, where the amount of the default is not less than 1000 rupees, provided that the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 lakh rupees. Fresh start process. Who may file application for fresh start? Under section 80 of this code, any debtor who fulfill following eligibility criteria may file application for fresh start for discharge of his qualifying debt. Gross income of debtor does not exceed rupees 60,000. Aggregate value of assets or debtor does not exceed rupees 20,000. Aggregate value of qualifying assets does not exceed rupees 35,000. Not an undischarged bankrupt, and he does not own a dwelling unit. Fresh start bankruptcy or insolvency resolution process is not substantive. Application can be filed by debtor himself or through resolution professional. Next, interim moratorium. It is a period in which all legal proceedings deemed to have been stayed and creditors cannot initiate any legal action or proceedings against such debt, and it will start from the date of filing application for fresh start and we will applicable till the date of admission or rejection of application. Documents and reports. Application for fresh start shall contain following information and must be supported by affidavit. List of each debt owed by debtors. Interest payable on such debt. List of security held. Financial information of debtor and his immediate family, that is 2 years. Personal detail as may be prescribed. Reason for making application. Particular of legal proceedings against him. Confirmation about no earlier fresh start order. Next, procedure for appointment of resolution professional. If application is filed by resolution professional, then within 7 days of receipt of application, AA will direct the IBBI and seek confirmation that no legal proceedings is pending against such RP. RP is resolution professional. Then board will communicate acceptance or rejection of appointment of RP. If application is filed by debtor himself, then AA will direct board within 7 days from the date of application to nominate name of RP suitable for fresh start application. Board shall nominate RP within 10 days from the date of directions issued by the board. Next, responsibility of resolution professional after appointment. RP shall examine the application within 10 days of appointment and submit a report to AA. Report will contain information about qualifying debt and liabilities eligible to discharge, adjudicating authorities power to accept or reject application. Within 14 days from the date of report by resolution professional, AA will decide on the matter of admission or rejection of application. Order of acceptance must contain amount of qualifying debt by resolution professional and amount eligible for discharge. Copy of order passed by A shall be provided to the creditors mentioned in the application along with copy of application within 2 days from the date of passing order. Next, objection of creditors. Within 10 days from the date of order of AA, objection may be raised by creditors whose name is included in order, which respect to inclusion of debt as qualifying debt or incorrectness of detail of qualifying debt. Application for objection should be given to resolution professional. Within 10 days, RP will accept or reject the application. Application against the order of resolution professional. Within 10 days from the date of acceptance or rejection of creditors, objection by RP, either debtor or creditor may challenge the order before AA. AA will decide the matter within 14 days of such application. Next, discharge order. RP will prepare a final list of qualifying debts and submit such list to AA at least 7 days before moratorium period comes to an end. AA will pass discharge order at the end of the moratorium period for discharge of debtors from the qualifying debt. Next, standard of conduct. The RP shall perform his functions and duties in compliance with the Code of Conduct provided under Section 208. Next, insolvency resolution process. First, debtor. Under Section 94 of the Code, the filed an application for initiating proceedings in respect of debtor. It may either be submitted personally by the concerned debtor or through the resolution professional. The following are the conditions that must be met before submitting an application. The debtor should not be a bankrupt who has not been dismissed. In terms of his death, the debtor should be on the verge of a fresh start. There should be no bankruptcy resolution proceedings pending in respect to the debtor's debt. The debtor should not be in the process of filing for bankruptcy. During the preceding 12 months, no insolvency resolution procedure should have been admitted, as measured from the date on which a new application for activating the insolvency resolution process is filed. Once the debtor meets the aforementioned requirements, he or she is eligible to make an application to begin insolvency procedure. Next, creditors. Under Section 95 of the Code, a creditor for initiating insolvency resolution process in respect of individuals and partnership firm may make an application for the same either by himself, through a consortium with other creditor, or through a resolution professional. In the scenario where the debtor is a partnership firm, then the creditor can make an application against either of the partners of the firm. The application as made by creditors shall contain the required attachment as are prescribed in the code. The creditor shall also furnish a copy of the application as filed to the debtor for head reference. The creditor shall, while making the application, ensure that the application is in the appropriate format as prescribed in the code. Interim moratorium. An interim moratorium shall come into force from the date on which application for initiating insolvency proceeding is made and thereafter shall cease to have an effect on the date of admission of the application by DRT. DRT is Debt Recovery Tribunal. During the period of interim moratorium, neither by legal action nor pending proceeding shall be in execution, nor can the creditor initiate any fresh legal action against the debtor. In the scenario where the debtor is a partnership firm, then in such a situation, the interim moratorium shall be applicable against all the partners of the firm. Next, appointment of resolution professional. The resolution professional is the key person in the insolvency resolution process. The resolution professional may be appointed by undergoing either of the following. Pre-existing resolution professional. Where an application for initiating insolvency resolution process is filed by the RP on behalf of the debtor or creditor, as the case may be. Under this state, the adjudicating authority, that is DRT, shall direct the board, that is IBBI, to verify that as of date there is no disciplinary proceedings pending against the proposed resolution professional. The verification shall be directed to be conducted by the board within a period of 7 days from the date of receipt of the application. The board shall, on receipt of direction, report its decision, that is, recommending appointment or rejection of resolution professional, to the directing adjudicating authority within 7 days of receipt of direction. Fresh appointment. Where an application for initiating insolvency proceedings is filed by the debtor or creditor without the involvement of a resolution professional, then in such a situation, the adjudicating authority shall direct the board to nominate a resolution professional who can drive forward the initiated insolvency resolution process. On receipt of the aforesaid direction, the board shall nominate a suitable resolution professional within a period of 10 days. The board, while nominating the resolution professional, shall verify that no disciplinary proceedings are currently pending against the proposed resolution professional. Next, submission of report by resolution professional. On receipt of the application as filed, initiating for resolution insolvency resolution process, the appointed resolution professional shall examine the application as submitted by the debtor or creditor within a span of 10 days to be counted from the date of the appointment. Once the submitted application has been examined, the resolution professional shall then prepare a report, thereby recommending his decision as to whether the submitted application should be admitted or rejected. Next, decision of adjudicating authority. When the adjudicating authority receives the resolution professional report, it must issue an order within 14 days either admitted or rejecting the application. As it sees fit, if the adjudicating authority accepts the application for commencing the insolvency resolution process, the adjudicating authority may issue order to conduct negotiation between the debtor and creditors to finalize a repayment plan. Within 7 days of passing the order, admitting or rejecting the application, the adjudicating authority shall provide a copy to the creditor of the order admitting or rejecting the application. The resolution professional report as submitted to the adjudicating authority and the application are initially submitted for initiating the insolvency resolution process. Moratorium period. A moratorium period begins when an application for insolvency resolution process is accepted by the adjudicating authority and ends 180 days after the application for insolvency resolution process is admitted by the adjudicating authority or when an order on a repayment plan is passed by the adjudicating authority. During the moratorium period, the debtor as well as his pending legal actions and debt will be in a similar situation as during the interim moratorium. Next, public notice and claims for creditors. After admitting the application for commencing the insolvency resolution procedure, the adjudicating authority must issue a journal public notice within 7 days of the date of the order for the purpose of inviting claims from all creditors within 21 days of the date of the public notice. The aforesaid notification will be published in one English newspaper and one newspaper in the vernacular language. The notification must also be posted on the adjudicating authority website and posted on the premises of the adjudicating authority. Next, registration of claims of creditor. The resolution professional is the sole authority where the claims are required to be registered by the creditors. For getting the claims registered, the creditors may use the following medium of communication: electronic communication, courier, speed post, or registered post. Next, preparation of list of creditors. The resolution professional will compile a list of creditors based on the information received from the debtor's application for commencing the fresh start process and claims received from creditors after the invitations and registrations of claims which are received from creditors. Within 30 days after receiving the notice, the resolution professional will make every attempt to construct the aforesaid mentioned list. Next, repayment plan. In consultation with the resolution expert, the debtor must prepare a repayment plan that includes a proposal to creditors to restructure their debt. The repayment plan must also approve or provide the resolution professional numerous power, such as carrying out business on behalf of the bankrupt, realizing the debtor's assets, and administering or disposing of the debtor's assets. Next, resolution professionals report on repayment plan. The resolution professional shall, after successful drafting of repayment plan, submit the same along with the report of the adjudicating authority within a period of 21 days to be counted from the last date of the submission of the claim. Next, calling meeting of COC. COC is Committee of Creditors. The resolution professional shall, after preparation of his report on repayment plan, call a meeting of the Committee of Creditors by issuing a prior notice in this regard at least 14 days in advance of the finalized date of the meeting. The notification of aforementioned meeting must be sent to all of the creditors which are listed on the resolution professionals list of creditors. The address of the adjudicating authority to whom the repayment plan was served, as well as the report of the resolution professional on the repayment plan, must be included in the meeting notification. Seeking approval of creditors on repayment plan. For carrying on any business on behalf of the debtor, the consent of creditor is required. In this regard, obtaining approval of a repayment plan or any later amendment to the repayment plan requires the consent of a majority of creditors, representing 3/4 in value of the creditors present, in person or via proxy, at the convening meeting of the Committee of Creditors. Completion of repayment plan. The resolution professional must do his best efforts to finish the repayment plan execution within the given time, limitation, and in a timely manner. In this regard, the resolution expert must provide the specific documentation to the persons covered by the repayment plan's horizon, as well as the adjudicating authority, following the successful completion of the repayment plan. The resolution specialist must make sure that the paperwork are delivered within 14 days of the repayment plan completion. If the resolution professional is unable to provide the information in a timely manner, he may approach the adjudicating body to request an extension to the time limit for providing the information. Once the AA is satisfied, then it shall grant an extension of not more than 7 days to comply with the requirement. Next, discharge order. On the time-bound and successful implementation of the authority's repayment plan, the resolution professional will contact the appropriate adjudicating authority to request a discharge order for the debt listed in the repayment plan. Only if the authorized repayment plan provides for earlier discharge or discharge upon completion of the repayment plan. The resolution professional may approach the adjudicating body to seek discharge order. The board must also get a copy of the adjudicating authority's discharge order for its record. The insolvency resolution process is the first step in dealing with defaulting individuals and partnerships. An application for bankruptcy might be made after the insolvency resolution procedure has been completed successfully or during the course of the insolvency resolution process. During the bankruptcy resolution process, all parties, whether debtors or creditors, must corroborate with their assigned resolution professional in order for him to efficiently complete the insolvency resolution procedure and obtain a discharge order. Next is bankruptcy order. When the adjudicating body receives confirmation or nomination of the bankruptcy trustee, it must issue a bankruptcy order within 14 days. When the bankruptcy order is issued, the adjudicating authority must provide a copy of the bankruptcy application as well as a copy of the bankruptcy order to the bankrupt creditors and bankruptcy trustees. The adjudicating authority's bankruptcy order will stay in effect until the debtor is finally released of his debt via discharge order. If a bankruptcy order is issued against the firm, it will affect all people who are partners in the firm as of the date of the order is issued. On the passing of the bankruptcy order, the state of the bankrupt shall stand transferred to the appointed bankruptcy trustee, and later the formed estate shall be disturbed among the creditors. The creditor shall not initiate any fresh legal action or proceedings against the debtor or against his property without the prior approval of the adjudicating authority. Next, modification or recall of bankruptcy order. Regardless of whether the bankrupt is discharged or not, the adjudicating authority may amend or recall the bankruptcy order at any point after it has been issued, either on receipt of an application or on a suo motu basis. Only in certain circumstances can an order be modified or called back. On this note, the following are the scenarios in which the past order can be amended or recalled. That are, when an error is clearly visible when looking at the order, when bankruptcy debt and related expenses have been paid off or secured to the satisfaction of the adjudicating authorities. Any sale or alienation of property or payments made by the bankruptcy trustee will be legitimate if the bankruptcy order originally issued is changed or rescinded by the adjudicating body. It's vital to remember that property disposed of after a discharge order remains in the ownership of the person appointed by the adjudicating authority. And if no one is appointed, it reverts to the bankrupt on the terms set by the adjudicating authority. The amended order, which was issued after the original discharge order, applies to all creditors whose obligations are still owed, and so forms part of the bankruptcy procedure. Next, this is authorities. Um, First, the role of Debt Recovery Tribunal, that is DRT, under IBC. DRT is the adjudicating authority for individuals, partnership, and proprietary firm under the IBC have been vested with various powers and rules. According to subsection 2 of section 179 of the code, the DRT shall have the power to entertain and dispose of the following: any application or proceedings by or against the individual debtor, any claim made by or against the individual debtor, and any question of priorities or any question of law or facts arising out of or in relations to the insolvency and bankruptcy of the individual debtor or firm under this code. Civil Code not to have jurisdiction. Under section 180 of the code, the Civil Code shall not have any authority to entertain any suits or proceedings in respect to any matters on which DRT has a power to entertain under the code. Also, the section 9 of the CPC, that is Code of Civil Procedure 1908, gives power to the courts to try all the suits of civil nature, except suits from which shall courts are expressly or impliedly barred. Therefore, by being barred by section 180 of the code, civil courts shall not have jurisdiction over matters on which DRT has jurisdiction. Next is GRT. The adjudicating authority for individuals and partnership firms, as mentioned above, shall be the DRT having territorial jurisdiction over the place where the individual debtor actually or voluntarily resides or carry on business or personally works for gain. Next is GRAT, that is Debt Recovery Appellate Tribunal. Once the application under IBC is admitted by the DRT against the individual or partnership firms, then any person aggrieved by the order of DRT may prefer an appeal before the DRAT. Every appeal shall be filed before DRAT within 30 days. An appeal can be filed beyond 30 days if DRAT is satisfied that there was a sufficient cause for not being able to file within the 30 days duration, but then within 15 days period after 30 days only. Next is Supreme Court. If a court is dissatisfied with the DRAT decision and feels aggrieved, he or she may file an appeal with the Supreme Court. The application must be based only on the legal issue that arises as a result of the order. The application in front of the Supreme Court must be filed within 45 days of receiving the DRAT order. The Supreme Court, on the other hand, may grant an extension of more than 45 days if it is persuaded that the person was prohibited by a sufficient clause. Only a 15 days extension beyond the 45-day period is permitted. That's all. Thank you.